What are the major changes in Indian Evidence Act, 1872 and Bharatiya Sakshya Adhiniyam, 2023? The Indian Evidence Act, 1872, enacted during the British colonial period, had a limited scope regarding modern technological evidence. The definition of a document under the IEA traditionally focused on physical records like writings, maps, or inscriptions, which reflected the technology of the 19th century. Electronic evidence, though partially covered by a later amendment, was typically classified as secondary evidence and required strict procedural steps, notably a complex certificate under Section 65B, to prove its admissibility and integrity in court. Similarly, the concept of oral evidence was restricted to statements spoken by a witness physically present in court, limiting the court's flexibility in managing testimony. Now let's discuss about the major changes in the Bharatiya Sakshya Adhiniyam, 2023, which completely modernizes the law to align with the digital era. The key change is the explicit inclusion of electronic and digital records within the definition of a document itself, which means digital evidence, such as emails, server logs, smartphone messages, locational data, and voicemails, is now generally classified as primary evidence, treating it as equal to a paper document. Furthermore, the scope of records is expanded to cover data stored in semiconductor memory and communication devices, future-proofing the law against evolving technology. The BSA also broadens the definition of oral evidence to include statements given electronically, like testimony via video conferencing, thereby enabling virtual court proceedings and remote testimony for witnesses, victims, or the accused. Indian Evidence Act, 1872. The term confession was not explicitly defined in the statute itself, forcing courts to rely heavily on judicial precedents and past judgments to determine what legally constituted a confession. A confession was deemed irrelevant, and thus inadmissible, if it was proven to have been obtained through inducement, threat, or promise. Furthermore, a confession made by one accused person during a joint trial could be potentially used as evidence against their co-accused, a rule that often complicated multi-party cases. The Bharatiya Sakshya Adhiniyam, 2023, introduces crucial changes for clarity and protection. Most significantly, the BSA explicitly defines confession for the first time, providing a clear and uniform statutory basis for this crucial term. To enhance protection against forced statements, the BSA expands the grounds for irrelevance by specifically adding the term coercion to the list alongside inducement, threat, or promise, thereby explicitly recognizing and criminalizing this method of obtaining a confession. Regarding joint trial confessions, the new act adds an important explanation that clarifies the application of the rule, particularly addressing situations where a co-accused has absconded or failed to appear in court, ensuring legal clarity for trials conducted in absentia. Indian Evidence Act, 1872. The law applied to all judicial proceedings but notably excluded courts-martial, creating a gap between civilian and military justice systems. Furthermore, the IEA was riddled with archaic, colonial-era language, using outdated and disrespectful terms like lunatic and idiot, and frequently referenced the UK Parliament. Regarding procedural scope, the rule for judicial notice primarily focused on domestic laws and specific acts of the UK, and the scope of secondary evidence was limited, while expert opinion was restricted to a few defined fields such as foreign law, science, or handwriting. Bharatiya Sakshya Adhiniyam, 2023, systematically updates these aspects. It explicitly applies to courts-martial, thereby harmonizing the law of evidence across most civilian and military courts. The BSA consciously removes the colonial-era language, replacing it with modern, respectful, and indigenous terms such as person of unsound mind and advocate, aligning the legal text with contemporary sovereign and inclusive values. In terms of scope, the BSA expands the requirement for judicial notice to include international treaties, agreements, and conventions of which India is a part, modernizing the country's legal recognition of global commitments. Finally, the BSA broadens the scope of secondary evidence to explicitly include oral and written admissions, and significantly expands the acceptance of expert opinion to include the view of any person skilled in any field that requires specialized technical knowledge, allowing courts to rely on experts in a much wider range of modern subjects. Conclusion. The Bharatiya Sakshya Adhiniyam, 2023, BSA, represents a transformative and essential leap forward for the Indian legal framework, effectively retiring the obsolete Indian Evidence Act, 1872, IEA. This legislation successfully achieves two main goals: modernization and decolonization. Modernization is evidenced by the seamless integration of electronic records as primary evidence and the introduction of virtual testimony, which makes the justice system technologically ready for the 21st century. Decolonization is reflected in the removal of archaic language and the application of the law across systems like courts martial. By explicitly defining confession and strengthening protections against coercion, the BSA aims to make evidence procedures clearer and fairer. Ultimately, the BSA 2023 is designed to deliver a more efficient, logical, and contemporary judicial process, firmly grounding the law of evidence in Indian sovereignty and modern societal realities. Follow for quick law videos. Like, share, subscribe. Command in Law.